Hello, hello, hello. It's Attorney Mike Raven coming to you from Chicago. As usual, it's St. Patrick's Day weekend. Probably doesn't mean much to a lot of you, but that's big doings here in Chicago. Oh, it's a good excuse to drink. It really is. Not that I'll be doing that. We are having a Friday happy hour here. I'm rolling with soda myself. Got a couple good clips. I have to thank Rocky Lennon, who's absolutely on a tear. Absolutely on a tear. And Lokificent Slayer, I see in there. She's sending me stuff. I am even one that I use one that I got just 2 minutes ago that I haven't seen. Who knows? Let's see how the evening goes here, shall we? Let's get this party started.
Now I've been doing this long enough. I try to look a little bit deeper. Things have slowed down for me. This is a retail fraud, but what the defendant did was he didn't steal like a deodorant or some soap or something like that. He ended up stealing 78 monster cans and 32 Red Bulls.
Court calls the case of the People versus Maurice Jones.
Some people call me the Space Cowboy.
Maurice Jones. This is a nugget I missed from yesterday. It's good. I'm sure it's made the rounds.
Predictions on behalf of Mr. Jones.
A lot of you have probably seen it, but it's good.
Maurice Jones. What are we doing?
Gunner, we'd like to set this one for a preliminary examination.
You see the bond violation report?
I do. So I did have the opportunity to talk to Mr. Jones about this. He does have his medical marijuana card.
Okay, does he have a medical cocaine card?
He does not. Whenever I spoke to him about it, he did inform me that he is retesting.
And there's all you need to know about how Judge Simpson feels about the situation.
For those. Based on he is retesting for the March 11th or sending it into the labs. Whenever we discussed it, he explained to me that he did have another test done. His test came back negative. Okay, a 12 panel. His test came back negative, but the Lenawee County came back positive. So he is
also, some call him the gangster of love. I'm just saying.
Disputing that.
His test came back
Negative.
which test?
From my understanding, it's the March 11th, correct? And then did you also do that for the January 31st?
Yes.
Yes.
Well, the previous ones that I violated on, I was.
Okay, before you go on, okay, I'll let you go and explain anything you want to explain. I don't have a problem with that. However, looking through your report, you continue to test positive for marijuana, but from September 2023,
Yes.
there was cocaine in your system.
Yes.
November.
Judge, I don't think you understand. He's completely clean on all of his own unverified tests.
11, 2023, cocaine in your system.
Yes.
December 18th, cocaine in your system. January 31st, cocaine in your system. March 11th, cocaine in your system.
I'm only think about it. It's a cop where I'm testing that.
Pardon?
Where I'm testing that in Lenawee County. It's a cop with other matters I'm dealing with, and I'm going through a thing right now where they're setting me up. I started bringing my own panels to the place that I drop at. They use a dip thing, and I use a urine test, and my test came back up negative, and they test came back up positive. And I'm telling them I never even did cocaine. And I ain't even about to sit right there and try to justify it in court. That's why I accepted one of the violations. But Fresh Harbor told me if I honestly didn't do it, fight it. And I never even did know. And it have to be in you. I looked it up. I read about it. So now I started going in there and taking my own test. And I have witnesses with the people that I took the test with at the
Look at the body language from Judge Simpson. He could not be non-verbally screaming, "I don't believe you" anymore.
place just on the 11th. That mine showed negative.
I just gave you all of the dates that you tested positive for cocaine.
No, but I've been trying to, I wasn't smart enough to, funds.
I just gave you the dates that you tested positive for cocaine. You're telling me that all of those are
negative.
All of those are wrong?
Yes, all of them. Every last one of them. And I won't sit right here and lie to the court. But I did accept.
You want me to call over and get the levels of cocaine that were in your system? Because they have them.
But I've never used in my entire life, ever. And that's why I wasn't smart enough in the beginning with buying my own tests to go there. I was using them at home. But then on the 11th, I told myself, like, why am I doing them at home? I need to be doing it in front of the people so they can see that blah, blah, blah. And then the person that...
Mm-hmm. Okay, I'm assuming that's a yes. Okay. Mm-hmm.
I dropped with mine, and he tested me with the dipstick, and the dipstick showed that I was positive, and my test showed I was negative. And he took a picture of it. I got photos of it. His name is Mike.
His name's Mike, Judge. So you know it's all legit. You know everything's good.
And I never use, and I won't sit right here and lie to the course. When I drop twice a week for the last. I don't miss a test. So why would I actively use cocaine once a month? I'm from Detroit. Why would I actually use cocaine once a month if I'm an active user? And then I'm going to every court day. I'm sorry.
What the hell is he talking about? He's positive every time. Why would you use cocaine to get high? Why would your test come back positive all the time? Because you're getting high all the time. This isn't hard.
I'm going to every schedule. I don't miss one. I'm saying I don't miss a drug test.
You don't know Shakespeare, do you?
No. I just don't miss a drug test. So I wouldn't come to your court and.
Judge Simpson, were you fixing to drop a Shakespeare reference in here? Because trust me, it would be wasted, sir.
Tell you to your face that I don't do it, but I haven't missed a drug test, but I'm doing cocaine. Like they setting me up, and I'm trying to handle the situation, and I am handling it with the lawyer. I talked to her, and she said she can help me with the matters of up there, but I'm testing there, and they're setting me up, and that's all I can say. Other than that, I've never used in my life, and that's on my son, my mom. But anyway, I never used in my life ever.
I gotta find
not, you know me, nothing ever, nothing.
We all know what's going on here. That's right.
You done?
Boy, I'm just getting railroaded here.
And I ordered a swab, like, cause once you drop. Okay.
Your Honor, I advised him that if he wants to dispute them in the future, he has to do that with the Lenawee County, basically send it in for testing.
That Lenawee County did what?
That he would have to send it in for testing if he wants to dispute that in the future.
Is he taking them here or in Lenawee?
And Lenawee. And then it's basically getting sent to the community corrections here.
Mm-hmm. I don't know. I probably looked at what seems like probably 1 million of these. The odds of this happening are like nil. So when are they supposed to have the results of the test from the 11th?
We received any information for that?
No, you just told me I had a violation for it.
Has he ordered a retesting of that sample?
besides the original test?
The one on 11.
Yeah.
Yeah, well, with the dude Mike, the new dude. Yes, he took
What?
Yes, with the new dude Mike, he took a picture of my testes and was supposed to.
The new dude Mike took a picture of my testis. I can't even. I don't know.
Send them in, and it cost $60. Yes.
You took a picture of your test.
Of mine in the test, sent it to the probation officer or the bonds officer, and yeah, they were supposed to send it out. But I never even knew I had this violation. Because when I left out of the place, we was all good. He would have told me that I dropped positive, and he never told me that. And I stayed there until all my tests is clear.
So why is it being sent out to be retested?
Yes, it should be. And if it's not,
well, hold on. What do you mean it should be?
Did you pay the $60?
Did you do it?
He never told
Did you do it?
He really does sound like
never
Kevin
told
Hart.
me that I was.
Hold it. I just thought you told me that he did.
I was under the understanding he did. I think that he might.
Yeah, well, that's what he also said in his little soliloquy he was giving.
No, I know. He told me I was good.
His little soliloquy about testises.
He will handle it. If he said if Darren said something that he was going to handle it. So I ain't press the issue because I knew I was clean and he seen it on the thing. So he told me I can
When?
He said when?
He said young man.
March 11th, you test positive for cocaine again.
Want to still be on my system now if I did it that early or some type of hair follicle blood.
March 11th, you tested positive for cocaine again for the 5th time.
Yes. And all of them, I never did cocaine in my life. And it's hard based off the cases I'm dealing with, but I can't make you believe, but I won't come to court if I violated 5 times. Knowing this.
You know what? You keep talking to me. That's not going to stop me from doing what I'm going to do, but I'm going to let you go on and get everything out. You then told me that you were sending that one in. And now I find out you haven't even sent that test in. And then you're telling me that I didn't know that it was positive and that you didn't know about this. What you're telling me doesn't even make any sense. You haven't sent that sample back to be tested, have you?
No.
Why not?
Because Mike said he would handle it once he talked to Darren. Because my test came up negative. His test came up.
Well, the PD is going to have to call up and try to figure out what the heck's going on up there in Lenawee then, because I'm just telling you, you don't see this.
Can I ask you a question since you're the judge?
Go ahead.
I just want to know how many active users have you seen drop 8 times a month and drop 30 once? I dropped 30 once since.
How many active users have I seen do that? Young man, I've been on the bench almost 25 years. How many do you think?
Like once. I assume they might drop twice.
Let's do it this way. Because I think he's going to have to learn to tell me the truth, because that's not the truth. This doesn't happen. And if you think you're going to get up here and just kind of try to fast talk me into doing something, no.
I'm not.
It doesn't work that way. And why would you know anything about active users and how many times they would drop dirty in a month?
Only because I'd have been in the system.
Cause conference will be adjourned to next week. What, let's see, March 21st, 2024, 9 a.m. Council, you can maybe have that conversation about coming before me and telling me the truth, but at this time, defendant's bond is revoked. You are remanded.
You need to turn yourself into jail right now.
So we have Ms. O'Brien, we have Ms. Futterman here from Thurston County. So we have two motions that Ms. O'Brien has filed in this case to start with that I think we need to address. Ms. Futterman, have you seen those two motions?
Your Honor, I saw a motion to change venue. I did not see another motion.
The second motion was a motion to dismiss your filing with the court and on the basis that you're an attorney and there are not supposed to be attorneys present in these cases.
I've not seen that. I think that would support the county's position that perhaps this is not appropriate for small claims court and therefore should be dismissed from small claims court. But I've not seen that motion.
May I give my 2 cents on that?
In a moment, you may.
I have not seen this. I do not know what we're getting into. It's Rocky London's fault. That's all I'm telling you.
Let's start out by saying this with in regards to the motion for a change of venue. The reason I'm hearing that case today is because I am not a full-time employee with Thurston County. I am an attorney and I do pro tem work. So I'm an independent contractor, if you will, in relation to that. I am being paid by the county to be here today, however. Now, your initial motion, Ms. O'Brien, was to move this to another jurisdiction. You mentioned Mason County because you were concerned that you couldn't get a fair shake in court here. Is that right?
That is correct, Your Honor. Today I am willing to withdraw that motion, seeing as how you are here. I understand your salary is still paid by Thurston County. However, I'm happy to bend a little bit in this situation as you are a pro tem, and that did satisfy my concerns.
Oh, good Lord. We've got a Karen.
All right. Fine. We will then strike the motion for change of venue.
Only my chat.
Thank you, Your Honor.
All right, so we'll go to the second motion then before we talk about any of the merits of the case. And that will be to prevent the document filed by Ms. Futterman on behalf of the county. So let's hear from you on that one, Ms. O'Brien.
I brought my case to small claims court because I'm not prepared to fight an attorney. I'm not interested in paying attorney fees. I'm not exactly sure why Ms. Futterman filed anything in this case prior to getting the court's
Everybody else is absolutely fascinated with paying attorney's fees.
approval. I do believe that they're supposed to get the court's approval. And as you know, you are more than welcome to allow them to represent Thurston County. However, I'm not prepared to fight an attorney, Your Honor. And as such, I don't believe any of their pleadings should be entered. They knew they weren't allowed to appear. They could have brought, I believe the new county manager is Leonard Hernandez. He could have appeared. He could have entered these documents. Alas.
Well, Karen, we have common ground. We agree with that. We agree with each other on this much. You're over your head.
An attorney appeared. An attorney entered the documents without approval by the court. So I'm asking for a default today. because there's no one here on the other side. Thank you.
All right, Ms. Futterman, first to the issue of your appearance on behalf of the county.
Yes, Your Honor. First, I'd asked, did the court have a chance to review the filing, the documents that were filed on behalf of the county? Specifically,
I did.
Okay, I just want to make sure of that. So we've got sort of a perhaps a bit of a conflict disagreement between the various statutes. And specifically, the district court statute, RCW 12.40.080, provides that no attorney shall appear in small claims department without consent of the judicial officer, but then goes on to say a corporation may not be represented by an attorney at law or a legal paraprofessional except as set forth in a statute that doesn't apply here, which is RCW 12.40.025. That authorizes attorneys to appear in small claims court if a case is transferred in and the attorney's already representing a party. So that statute, 12.40.080, provides no attorney is to represent a party, whereas under the specific statute with regard to prosecuting attorneys in counties, RCW 3627.020 provides that the prosecuting attorney shall appear and represent the county in all civil proceedings and defend the county in all suits. And so it's mandated by state law that the prosecuting attorney represent the county in all proceedings. So given that, I think there's a bit of a legal dilemma for the court in that we are mandated to represent the county here. And therefore, there really is no basis to either strike pleadings, and in this case, I think there's a real question as to whether this really should proceed in small claims court.
Ms. O'Brien, your response?
My response is Ms. Futterman just made it very clear that she's aware that she shouldn't be here without authorization by the court prior. And so I renew my motion for default and my motion to strike her pleadings. Again, I see no one here from the county except Ms. Futterman. And she's very well aware she needs your approval to be here first.
Happy birthday, Nadine.
I see no one else, Your Honor. I don't think I should be penalized for their lack of planning. I planned very well for this. Thank you.
All right, here's my thought.
Judge, my planning is impeccable, but I don't know what I'm doing. Those those are her first two propositions for the court.
On this, Ms. Futterman, your discussion of RCW 12.40, et cetera, and 3627.020, that's just a reason why Ms. O'Brien is concerned about not being prepared to address a defendant who is represented by counsel. We're going to get real technical on rules and so on and so forth. On the other hand, Ms. Futterman makes a good point in regards to RCW 3627.020 in regards to the duties of the prosecuting attorney. I think under the authority that I have as a small claims district court judge, I can authorize the county to be represented by their attorney in this case. When I thought about this, I thought, what is the difference? What is the harm here? And Ms. O'Brien, as you pointed out, somebody else from the county could have been here, the new county administrator or the human resources person and so forth. But the reality of the situation is, based on my experience, that they would have been consulting with Ms. Futterman anyway about what to put in the document that was coming to the court for consideration today. So I don't see that there's any harm to Ms. O'Brien in allowing Ms. Futterman to represent the county in this matter. Plus, there is the statute that Ms. Futterman pointed out requiring the prosecuting attorney to respond to all claims and cases filed against the county. So I'm going to dismiss the motion to strike pleadings from the county, and we'll go forward then on your petition, Ms. O'Brien. So I'll hear from you in regards to that.
Thank you very much, Your Honor. My case is pretty simple. I've laid it out very well in my trial brief already. I worked for Thurston County as a court clerk, a deputy. I actually really loved it. I loved working at the front desk and assisting the citizens. It was great. Unfortunately,
yeah, no one cares, Karen. Move along.
You know, when I left, I didn't get a fair shake. It's laid out very clearly in my trial brief. I wasn't prepared to respond to the county's reply because I truly did not believe they would be allowed to appear for the county. So given that,
I'd also like to give a shout out to our sponsor, Global Septic Tank Service, for all your septic tank service needs.
simply ask that I not, if this doesn't go my way today, I really, really object to paying any attorney's fees because I was not prepared to be fighting an attorney today, Your Honor. But I do ask that you I'm sure you've already.
I might have to clip, really, really object. I might have to clip it.
You reviewed my trial brief as you let Ms. Fetterman know. So that's my case, Your Honor. I do believe I'm owed the $2,500 bonus that Thurston County gave all the employees. And I do believe I'm owed the COLA as.
Any objection? All objections.
Thank you.
Well, before you go, let me ask you, why do you have that belief?
I have that belief because the exhibits that I gave you, let's see, I'm sorry, I have the working COLA agreement, Exhibit D, I believe pages 90 through 91. It says on there that a 4% COLA was actually supposed to be quickly given to employees. And that was signed back, what was it? I'm sorry. Let me go to page 90 and 91 here. That was actually signed back in June. And I didn't leave my position until September, Your Honor. Furthermore, the $2,500 bonus, it was originally offered as a $1,500 bonus to anyone that wasn't in the union. And that was during very tough negotiations between the union and the county. I made some accusations, but I'm not going to go into that here. It was unfair that they offered it to non-union members, but not union members. So I do believe I'm owed the $2,500 that made that correct as well.
So your belief is that the COLA agreement was signed prior to your resignation from your position. Is that right?
That is correct. I'm looking at page 90 and 91 of the Exhibit D, Your Honor. And I'm sorry, I did not provide the county with this because I did file it timely and they could have got it off the small claims thing if they had looked.
All this crap is related.
All right, Ms. Futterman, your response.
I think Ms. O'Brien has a fundamentally flawed understanding of the union contract. First of all, as stated in the response that we filed, this is contractual. We're talking about a union contract. There's a contract between the county and the union on behalf of the union members. At the time the contract was agreed, Ms. O'Brien had left employment, was no longer a member of the union, and therefore had no benefit of that contract as a union member. So it's a contractual provision. The language specifically in the union contract that was agreed to states that the COLA, the employees covered by the agreement who are employed in the bargaining union at the time of union ratification of that contract were entitled to receive retroactive payment. And in addition, that the bonus amount of $2,500 for employees covered by the agreement is to be paid by employees employed during the pay period in which payment is processed, which was upon ratification of the agreement. So again, both of these were approved by contract after after Ms. O'Brien had left county employment. I guess in addition to, as I understand what she was saying with regard, I just pulled up that agreement, and I think what Ms. O'Brien is referring to with regard to a COLA, she referred to page 90. I think she mistakenly pulled up an MOU, which was attached to the union contract. That June, looking at our contract, there is a June 13th MOU. And if we go back a couple pages, and I hope the court has a copy of the contract. There's an MOU where it starts on, it's numbered page 86. So it would be pages 86 to 91 of the contract. That MOU only applies to overtime exempt employees. So if we turn to page 86 of the contract, it specifically says the purpose is to reach an outstanding issue regarding overtime exempt employees who were identified during it's a unit clarification process, which is a process through the State Public Employment Relations Commission to identify additional bargaining unit members. In any case, what Ms. O'Brien is referring to.
See, Judge, this is exactly why I didn't want this competent bitch here.
Did not apply to her position at all. She was employed as, I believe, a clerk's judicial support specialist, which was not an overtime exempt position. And there is provision in the, in the union contract that clarifies that. All of the positions covered by that union contract are listed in the contract. And I'm looking. Her position, the clerk's judicial support specialist, is on page 58, which is not a overtime exempt position. The overtime exempt positions are listed separately on page 63. So the provisions she's referring to, that MOU signed on June 13th, specifically does not apply to her position in any case. So I wrap this up. The union contract clearly does not apply and does not authorize granting any kind of retroactive pay to employees who left employment prior to ratification. And for all these reasons, we'd ask that the court dismiss the claim.
Thank you. Ms. O'Brien, before we get back to you, I must say that when I reviewed all these documents last evening, I had sort of the same conclusion that your timing was wrong in this case. And that is that the documents, the contract documents, seem to say that, you know, this applies retroactively to anyone in the unit, the bargaining unit, on November 14th, 2023. And you had resigned in September of 2023. And in other parts of the document, it says the agreements are only effective when they are signed. And that didn't happen until sometime might have been actually in January of this year before the final documents were signed. So can you tell me, Ms. O'Brien, where in the contract, if you've had an opportunity to review that contract, does it say that the benefits are retroactive, meaning they go back and apply to anybody who worked for the county between January 1 of 2023 and the time the contract was signed?
No, I'm sorry, Your Honor, I cannot, because I don't view this as a contractual issue at all. I view it as a fairness. I worked there for, you know.
Oh, sweet Jesus. Oh, no. She brings a claim sounding in contract, citing a contractual provision, and then she says, no, it's not about the contract, it's about my feelings. I don't know where to begin.
Quite some time. COLA was retroactive, as shown when I told you, page 90 through 91, for overtime exempt employees. That was back to June. That sounds pretty fair. I don't understand why the county felt that they needed to wait this long, take this long, to give a COLA to me working at the exact same time.
When you're making stuff up in the law, you use the term equity, not fairness. It's basically the same thing, but she just sounds like such a noob.
That one was signed. So it's not a contractual issue, as Ms. Futterman has suggested. It's a fairness issue at this point. And I still 100% believe I am entitled to that 3.5% COLA for the year of 2023, as well as the $2,500 bonus.
Wait a second. I don't believe it. We have a Karen who feels like she's entitled.
Thank you.
So Ms. O'Brien, Ms. Fetterman has said that the June 13, 23 agreement, memorandum of understanding, addressed overtime exempt positions. Do you agree that that was correct?
I agree that that's what the document states, yes.
And it was your position, an overtime exempt position?
No, it was not. However, I still understand that Thurston County understood that a COLA percentage at that point was 4%. Thank you.
Ms. Futterman, anything else from you?
Nothing further. Thank you.
All right, I'm ready to rule on this. Ms.
Yeah, I think so.
O'Brien, I have the opposite view. I think this is a contractual issue. I agree that the underlying question might be one of equality. You did work there for an extended period of time and a goodly portion, almost 9 months of that year. However, the union did not negotiate a provision in the contract that says the county is to pay anybody else who worked during the course of that year, but wasn't employed on the date that the documents were finally signed.
But the poor guy that gives it to her, can you imagine?
And authorized. So that's why I asked you the question, where in the contract does it say that this is retroactive? I couldn't find it. I suspect Ms. Futterman would have pointed it out to me if it was there. I suspect you would have pointed it out to me if it was there, but it's not. So I don't think that your petition today can be granted because, again, I believe the contract language is clear in terms of when the COLA and the retention bonus were to be paid. And they were to be paid after the time that you left service with the county, and the contract, to my way of thinking and my way of reading, says that you had to be employed and a member of the unit at the time the contract was signed in order to qualify for those. So I'm going to find against you, Ms. O'Brien, find that there's nothing to be taken by you in this case, and essentially grant judgment to the county. I'm not authorizing any kind of attorney's fees or other fees in this case.
Thank you for your time, Your Honor.
Okay, that be a no.
Appreciate you being here today.
You're welcome. Thank you.
Thank you.
Thank you, Ms.
All
Fetterman.
right.
I really enjoyed this. I really appreciate your time. Have a great day.
So did we. Bye-bye, Karen. Oh, good Lord. No, I got plumbing guy. All right, I'm gonna try this. Lokificent just sent this to me. I didn't have a chance to look at it. Let's give it a go. We got a good group going here.
Yes, sir. Thank you. Oh, sorry. Thank you.
Mr. Wilson, you ready?
Yes, Your Honor.
And that's state of Florida. And Michaela Fed.
That's correct. Ms. Fed, if you'll come on up, we'll be able to reach an agreement in this matter, Your Honor.
Okay.
She has two case numbers, and I don't have my docket. I don't remember the second case number, but the first case number that she's pleading to is 2399.
Okay.
It is my understanding that upon the successful entry of this plea, the state will be asking to consolidate the second case into this one.
Okay.
But only after the successful completion.
Okay.
So on 2399, she will be pleading, it's an open plea, Your Honor. She's will be pleading before the court open.
Okay.
It is the fleeing or attempting to elude high speed. It's a second-degree felony. It's the resisting without violence and possession of drug paraphernalia. She's to be adjudicated guilty, and as the court may require, remember that's by law. That's what a lot of the unfortunate hearing that we had last month was about. Was honestly, I wasn't able.
That's
to
what I'm
convey
saying
Ms.
here.
Fed, that's not optional. But we've had some discussions and we are on the same page today.
Perfect.
She's to pay court costs and fines. Other than that, Your Honor, there's nothing else on this plea form. And because it is an open plea, it's up to the court's discretion. And I've explained to Ms. Fed that she faces anything all the way from time served and nothing else, all the way up to 15 years in the Department of Corrections. She understands that.
Okay.
And I've indicated to her that, and I'll go over real quick with well, I guess I can wait till I pass it up to you. This will be her first and only felony, Your Honor.
Okay.
She has a misdemeanor history, but nothing other than.
And 23 total sentence points.
That's correct, Your Honor.
All right, Ms. Fed, you raise your right hand for me.
Yes, ma'am.
Would you tell me your name, your age, and your highest level of education?
My name is Michaela Fed. I'm 22 and high school. I graduated high school in 2020.
Did you hear Mr. Wilson's announcement about how you're going to resolve your case 23 CF99?
Yes, sir.
Has anyone promised you anything other than what Mr.
No,
Wilson
sir.
just stated? Has anyone promised you a sentence that the court may impose?
No.
Other than the minimum, as Mr. Wilson stated, time served all the way up to 15 years in prison? You understand that?
Yes, I do.
Anyone suggest to you in any way that the court may give you 2 years in prison or court may give you probation? Has anyone
Yes.
suggested to you?
Yes,
Anything?
I was informed of that. I'm terrified either way.
Or has anyone suggested to you what a sentence I may impose?
No.
Okay. Has anyone threatened or coerced you in any way to get you to enter this plea?
No.
You're doing so on your own free will?
Yep.
Have you had a sufficient amount of time to speak with Mr. Wilson?
Yes, sir.
Do you need additional time to speak with Mr. Wilson?
No.
Are you satisfied with the services?
Yes.
Has he done everything you needed him to do?
Yes, sir.
You understand by entering this plea, you're waiving your right to a trial by jury?
Yes, sir.
You're waiving your right to confront and cross-examine the state's witnesses?
Yes, sir.
You're waiving your right to compel the attendance of witnesses on your own behalf
Yes, sir.
and testify on your own behalf if you so decide?
Yes, sir.
And you're waiving your right to appeal anything other than an illegal sentence?
Yes, sir.
Have you been prescribed any medication you haven't taken?
No, sir.
You understand that you're not a U.S. citizen by entering this plea, it could subject you to deportation?
No, sir.
Do you have any questions at all, Ms. Fed?
No, sir.
All
Could
right.
I say something though?
I'm gonna give you that opportunity. Counsel, aware of any exculpatory DNA in this case?
Yes, Your Honor.
You are?
Oh, I thought you said what?
Are you aware of
Let's
any?
hear it.
Aware of any? No,
Okay.
I misheard you. No, Your Honor.
And I may have misspoken, but no, okay. All right, Ms. Fed, I'm gonna accept your plea as known, intelligent, and voluntarily entered into in case number 23 CF99. And as far as sentence, do we want to go forward with sentencing today?
Yes, Your Honor.
Okay, and I have a score sheet here. And Ms. Fed, it looks like you have 3 misdemeanors. battery or reckless driving, and culpable negligence. Those all sound accurate to you? 3 misdemeanors?
Yes, sir.
And the total sentence points is 23 sentence points. Did you review the score sheet?
Yes, sir, but I don't really know how points work.
Yeah, there's basically a statute that the legislature passed, and it assigns certain points to offenses. It gives us a calculation, and it's a guideline that the court reviews, and it gives me the lowest permissible sentence, prison sentence in months, and your lowest permissible prison sentence in months are 0. And generally speaking, if you score 22 points or less, I cannot sentence you to prison unless I make certain findings. If you score more than 22 points, I can sentence you to prison. You score 23 points, so I can sentence you to prison, but there's no lowest permissible prison sentence. You understand that? So I can sentence you from, as Mr. Wilson stated, time served, all the way up to 15 years in prison for the fleeing or attempting to elude high-speed reckless. The misdemeanors are misdemeanors. I can't sentence you to no more than 1 year in the county jail on those. You understand that? And as Mr. Wilson explained to you, it's a secondary felony and I cannot withhold adjudication. So you're going to be adjudicated guilty. You understand that? You're going to be a felon. Right?
Can I ask, what is the minimum that you can give me?
What is the minimum?
Yes, like, do you have?
Time served.
So what would that be?
That you've already served time in jail. Now basically sentence you to whatever days you spend in the county jail. Not sure how many days you spend in the county jail.
Not even sure if she got arrested. I'm just saying that it could be as low as time served up to.
So what does that mean, guaranteed jail time?
No, ma'am. No, it means anything from you'll leave here owing nothing more than a fine to you'll leave here in chains and going to prison for 15 years. He's trying to explain to you the extremes on both ends. Okay?
And it looks like you received a notice to appear.
So it wouldn't even be time served. It's
Yeah, so
probation to prison.
So I can sentence you to county jail time. I can sentence you to probation. I can sentence you up to 15 years in prison. But you're going to be a convicted felon.
She was, let me pull it out, Judge. She was first appeared and arrested.
In this case?
I thought she was, because it was
July
a
21st, Judge. And it looks like just spent 1 day in, so. It might be in the other case, Judge, that both cases are together on the first appearance sheet, Judge.
Okay.
Judge Patterson did it over the weekend, so.
So the bottom line is he has full discretion from nothing more than money all the way to prison.
And the other case that we're talking about is the battery on a person 65 years of age or older. And the understanding was if
it's my
I accept
understanding
this plea that the state will consolidate that case. Okay, so you won't. I've accepted your plea, and unless something happens today, once we finish this process, the state will consolidate the second case into this one. Okay. All right, Mr. Wilson. Anything you want me to consider? Want to call your client or any witnesses?
I will let her speak to the court, but I'd like a minute to speak to the court too. As the court has outlined her score sheet, this is her. It's not her first contact with law enforcement. It's her first serious contact with law enforcement. She's been in a little bit of trouble before, but she's literally 1 point away from almost, again, the court has discretion, but almost requiring the court for probation. That's what we're asking for clearly, is that you put her on probation. But I want to answer more to the last hearing. And Your Honor, things got out of hand and I bear some responsibility for that. I knew things were going the wrong direction. What I should have done as her attorney is continue this case and have the conversation that I was able to have before this one, so that things didn't go like they did the last hearing. Ms. Fed came off looking not like the person she really is, because she got emotional and was clearly trying to get the court to do something they couldn't do, but I failed in explaining it to her. And she does bear, I'm not taking all the responsibility. She bears some responsibility.
I want to see that hearing.
There's some to go around, and I just apologize to the court for letting it go that far. And I asked the court not to let what happened the last time sway your opinion on this one. I don't believe you will, because I told Ms. Fed that you're a very fair judge and that you will sentence her based on the facts. I just want to put that on the record, and Ms. Fed does want to address you.
I don't think you did anything wrong, Mr. Wilson. You're an excellent attorney. You've been practicing for decades. I didn't know.
Have to say that.
Well, we both have silver hair now, but I didn't know if Ms. Bev was generally didn't understand, or if she wanted me to, like you explained, do something I could not legally do. But that will play no role whatsoever in my sentencing. And Ms. Fed, you have any witnesses you want to speak to the court before sentencing?
I would just like to say I genuinely didn't understand. I was not trying to argue or cause a scene or show, trying to put on for anyone. I'm just scared. I'm still scared. I'm very emotional, and I'm trying not to stand up here and cry in front of everybody and look how I miss. So it's just very hard for me to hold my composure up here and actually talk like an actual person. I do want to apologize because we did look a hot mess. I just wanted you to take into consideration I have 2 babies that are 1 and 2.
How old are your children?
They're 1 and 2. And I own up to my mistakes. I know it was wrong. Obviously, it was freaking wrong. I ran from the police. I know I deserve to be punished for it, but I don't want, to walk around for 3 years with an ankle monitor. Life's already hard enough, and I already, I'm okay with probation for up to 5 years or whatever, but I just don't want to be away from my kids either. That's the biggest thing.
Where were your children when you were running from the police?
They're in school.
They were in school?
Daycare.
Are you not employed?
I am about to be. I just got a new job. It was really off and on, but I work.
Where do you work?
I'm not employed right now. I just quit the dollar store about not even 2 weeks ago. I'm about to start at Hunt's, a restaurant out there where Category 5 was. About to start bartending. So I do work. Me and their dad, that we both work. Every day. We're in their life every day. We take care of them every day.
They just drop them off at daycare and then flee from the police?
Yeah, it's happened honestly, almost just like that. I mean, we dropped him off. I went home, went back to get him from his apartment. Police were behind us. I went to my Mimi's house. We were about to go back home, and the police pulled right into the driveway. He got out and ran. I pulled off. He hopped back in, and I went. And obviously, it was wrong, but it happened so fast. It was like, what in the world, They're behind us. Why haven't they been turning the lights on us? They followed me all the way to my house, pulled in right into my driveway. I was like, it's just a weird situation.
If the police activate their lights, whether it's weird or not, you stop.
I was stopped. I was stopped in my driveway. The problem is I was wrong for starting again.
Why did you flee?
Because I didn't want him to leave me and go to jail. Because he didn't do nothing wrong. He missed court and tried to come. I know that was wrong.
So you have messed up your life for a man. That's a yes? Love. He's the father of your children? That's a yes?
Yeah, both of them.
We have to have a record. That's why he's asking you to
Yes.
speak out loud.
Yep.
There's a napkin there in front of you. Want to wipe your tears. Anything else you want me to consider?
That's it. I'm only 22. My life hasn't even started yet. I've already messed up enough.
Well, being 22 means that you're an adult.
Yep.
And that you are old enough to understand that your actions have consequences. I've sentenced people to prison that are a lot younger than 22. In fact, I believe I told you last time, someone with the same charge, high speed, reckless, running from the police in Port St. Joe, he's younger than you, I believe, is in prison. Ms. Smith, anything from the state?
Yes, sir, Judge. I would like to point out, first off, Judge, starting with the score sheet, one of the prior offenses on there that are scored in the prior record, Your Honor, I wanted to point out to the court that involved the vehicle as well. There were minor children in that when Ms. Fed was using her vehicle. to run another car off the road. Judge, that was the reckless driving and culpable negligence part. Judge, I believe that one of the children that was in the car was one at the time. We're talking about someone very young. So Judge, that is a history of using a vehicle to commit crimes, Your Honor. First of all, I'd like to point out that this occurred around 10:30 in the morning, Judge, and Ms. Bed and her actions caused great harm and safety issues to not only law enforcement that was chasing her, Judge, but to other in the public. Judge, she was driving over a van over 100 miles an hour down the streets of Port St. Joe. Cars were having to pull off the road, Judge. She was passing cars in no passing zones. It involved officers from the Port St. Joe Police Department as well as the Bulk County Sheriff's Office. And at one point, I believe it was Chief Richards had to actually block her from driving down Reed Avenue, which, as Your Honor knows, is the busiest and most congested street here in Port St. Joe during this chase, Your Honor. The state feels, Judge, that very strict punishment, as you're aware of our plea offer from the last time, Judge, at least an ankle monitor to help Ms. Fed and to protect members of the community, Your Honor. It is, once might not be a pattern, Judge, but two certainly is, Your Honor. And for those reasons, I just wanted to point those out to the court when you determine your sentence, Your Honor.
All right, Mr. Wilson, anything else?
No, Your
Ms. Fed, this is disappointing. I'll be honest with you. Driving 100 miles per hour, running from the police, and then you come to court and you start crying and tell me that you're 22 with 2 children. And then the state tells me that there's a past reckless driving, that you're running someone off the road and you had your children in the car. At some point, you're gonna have to grow up and take care of those children.
I'm ready to. All that.
You should have been ready when you had the first child. That changes your life.
I say that was over him, acting stupid over him. And I'm done with that. I'm done with that, honestly. And I'm calm. I'm not fighting no more. I'm not getting out my character. I don't want to do that anymore. Honestly, true.
So you said the last case was also over your children's father?
We're playing with me.
You're gonna have to decide whether you want your children to be raised.
No, I'm trying to find my own place right
Listen
now.
to me. You have to decide whether you want your children to be raised by you, or do you want your children raised by someone else while you're in prison?
No.
You're gonna have to make that decision. And it sounds like you do what you want to with your relationships, but if you're in the same environment with the same people and it continues to lead you into this courtroom, there's gonna come a day that somebody else is gonna be raising your 2 children and you're gonna be sitting in prison.
That's why
When do you start work, ma'am?
Monday. I just dropped the papers back off yesterday.
What's your schedule?
I'm not sure yet. I literally quit my job at the dollar store because I was intent on bartending and serving this summer. I want some tip money. I want to be in a restaurant this summer. I just dropped the papers off yesterday.
Yeah, what could go wrong with her?
Supposed to start Monday.
Bartending.
I had COVID this past week.
Who watches your children
My
when they're
kids
not
go
in
to
daycare?
daycare.
When they're not in daycare?
The only place my kids go other than with me in daycare is my Mimi's house where we used to live.
Your grandmother?
My grandmother, my sister, and my mama.
And they're available to watch your children if you're not able to?
That's my support system then.
All right, so what I'm gonna do, Ms. Fed, what you did was serious. You could have killed someone. Could have killed yourself. Could have killed some of the law enforcement officers. You could have killed some innocent citizens just simply walking down Reed Avenue. I can't excuse your conduct simply because it was on behalf of your child's father. It's a serious case. You're going to be adjudicated guilty of count 1. Fleeing or attempting to elude, high-speed reckless. That's a second-degree felony. What I'm going to do, I'm going to sentence you to 18 months prison.
No, please don't.
I'm going
Please.
to suspend that sentence. Listen to me. Pick your head up.
Listen to what he's saying.
Pick your head up, Miss Fed. Miss Fed, listen to me.
Turn your ears off, Miss Fed. Listen to him.
I know.
He suspended the sentence.
Miss Fed, pick your head up, ma'am. I'm going to suspend the sentence, okay? Do you understand that? If you're shaking your head, no. What that means is I'm suspending the sentence or I'm going to probate the sentence. So you're going to be placed on probation. And so long as you settle, you won't go to prison. If you violate your probation and the state can prove that you violate your probation, you're going to prison. So I'm going to give you this chance that you told me you wanted. You said you're changing. You said you've grown up. You've had a change of heart.
Yes.
I'm going to take you at your word. So I'm going to sentence you to 18 months prison. I'm going to suspend that sentence. You're going to be placed on 5 years probation, okay? You'll have court costs and fines, and I'll give you that amount in just a few moments. You have 100 hours of public service work. Your cost of supervision will be $20 per month. You must enter and complete a defensive driving school. You must also complete 6 consecutive weekends in the Gulf County Jail. That's starting today, okay?
What is that, this weekend?
Yes, so starting today at 5 p.m. until Sunday at 5 p.m. And that's Eastern time. You're gonna be in jail. So get your sister, your mom, your grandma to watch the babies over the weekend because you're gonna be in jail. So you got 6 consecutive weekends in the Gulf County Jail. Once you leave the Gulf County Jail, you're gonna have 6 months of community control. Okay? That's with the curfew.
That's my thought. I
If you're
needed
working, you
some.
can get with probation officers and let them know what your schedule is. And Madam Clerk, what's the court costs and fines? $1,008. And Ms. Fed, there are mandatory court costs I must impose. There are discretionary court costs I must impose. Do you want me to read off to you the discretionary court costs and fines, or do you waive my reading of those? Okay. Do you understand? You understand the sentence I've imposed?
Yes, sir.
So
I'm happy with that.
18 months prison. I'm going to suspend that sentence. You need to complete 5 years of probation. You need to complete 6 consecutive weekends in the Gulf County Jail starting today at 5 o'clock. Once you are released from the, say 6 consecutive weekends, but once you complete that condition, you'll have 6 months of community control. And Madam Probation Officer, is that clear?
So she starts her CC technically on Monday. After she gets out of jail for this weekend?
No, once she completes the 6 consecutive weekends.
Oh, okay.
No, because she's going to be out on the street during the week, so she'll start Monday. Correct. Okay.
So is that 6 months, so followed by 5 years, or is it?
It's 5 years probation with the first 6 months on community control.
Judge, $20 a month cost of supervision.
$20 a month cost of supervision. You got 100 hours of public service work. You must complete and enter the defensive driving course. You must enroll in that within 30 days of today. You understand that? Count 2, resisting the officer without violence. I adjudicate you guilty. You'll be sentenced to 1 day in the Gulf County Jail, given credit for 1 day in the Gulf County Jail. Count 3, possession of paraphernalia. I adjudicate you guilty. Sentence you to 1 day in the Gulf County Jail, and you'll be given credit for 1 day in the Gulf County Jail. Ms. Fed, if you violate your probation, you're going to prison. All right? You got 30 days from today to appeal the judgment and sentence of the court, and if you cannot afford an attorney, won't be provided for you. Any other questions?
Your Honor, may we request a DNA sample due to the?
Yes, and it'll be a DNA sample, and you'll be fingerprinted.
And Judge, since Ms. Vett entered this plea, we would at this time move to consolidate case number 23 CF 100 into the 23 CF 99, Judge. And if the court is willing, and this isn't something I spoke to Mr. Wilson about, but could, as part of the plea on 23 CF 99, Your Honor, if the grandmother that's going to be watching the children is Deborah Williams, she was the victim of the CF 100 case, and we would ask for peaceful contact with her during the term of supervision, Your Honor.
I already have peaceful
Yeah,
contact.
that'll be ordered. I believe I ordered that peaceful contact in that case. So peaceful contact will continue with Deborah Williams as part of your probation, since she may be watching your children. I ordered that, I believe last year in that case. So peaceful contact will be a condition of your probation.
Yes, sir. Thank you.
Miss Vett, go ahead, Miss.
Just notify Ms. Vett, Your Honor, that the DHS&B may apply additional penalties.
And that is true. They may suspend your license. Miss Vett, I hope I don't see you again.
Well, thank you.
Best of luck to you, ma'am.
That concludes my business, Your Honor. Thank you very much.
Thank you, Mr. Wilson.
Exciting and new.
Well, there you have it. I was ultimately disappointed. I wanted more jail time. But it's not, it's not my thing. And I'm glad she got some. But I'm not buying any of these justifications. None of them. Some jail time might do it. I don't know if that's enough. I think she needed to do 30 days straight to get it to get a real flavor of the situation. But what do I know? What do I know? That's just what my gut feeling is. I don't know anything about it. I'm not a judge. I don't want to be a judge. I'm not going to be a judge. Hell no. The one thing you've learned on Law Talk with Mike is being a judge is an awful, awful occupation. God bless the people who do it. That's all I can say there. All right, everybody. It's Friday. It's happy hour. Go behave yourselves. Take an Uber if you've been drinking. Don't get arrested. I'm not going to bail you out.